Yes, please. $33. Which case? There is a stay. It will be called, please. 33 is final hearing. Who appears for respondents? GP. We will call it. So we'll note down 39, madam. 39. 33. Note down. We will pass an order. Yes.
Well, so please just.
Huh?
The day before yesterday, one of my item was day before yesterday. One of my admission was listed at item 10. Day before yesterday, what?
So whatever has been done. We don't remember what has been done. Yes. Next.
Item 3, when item 3 is called, standing council reported item 10 also on the similar issue. And accordingly, your lordships passed an order.
Please file and review. We will entertain it.
But I filed a petition.
No, don't. This thing, Mr. Don't ask.
I filed a petition. I filed a petition.
Petition.
Immediate for being mentioned for recalling the order because that order is total unconnected at the instance of standing council that order was passed.
So you have filed an application for recall.
Yes.
That IA will come up on Monday. We hope that you understand the distinction between recall and review. You should file an application for review, not recall. Recall is. What is the distinction, Mr.? You are such a senior person. What is the distinction between recall and review? Examine it. We don't know. Examine it by Monday. Monday, we will take up. You better file a review. Because there is these recall and review are distinct legal connotations, not same. Recall means what you are trying to say that we have no jurisdiction to pass the order. That is incorrect.
Absolutely not.
That is absolutely incorrect. What you are saying is that this order could not have been, this suffers from error apparent on the face of the record because unconnected to facts of the case.
There is an order, I connected order. Yes.
Review.
Connected order,
I'll review or change the title, Mr. We don't know. Yes.
Lordship, kindly allow lunch motion pertaining to medical admission. Medical admission, sir.
What is medical admission? Which category? What?
D category, Your Lordship.
D means
Management category.
What you want? Consideration of your, how many?
Six, Your Lordship.
Yes.
Today's last day.
Yes. How many? All right.
Let's.
You have annexed the similar orders, we believe. Yes.
May I make a mention, my lord?
Lordship,
1 minute. We will hear you at the last. You are a separate and distinct class, right? So advocates first.
Lord.
Yes.
Teachers counseling, transfer counseling. Your lordship was pleased to allow some people, my lord, for counseling, my lord, mutual transfers. Both points were, my lord, given by.
That order has been passed after
In another case, Lord, I challenged the rules with regard to headmasters, they are not given the special points. The matter is urgent to, my lord, the other day. I filed an I-8 for advancing the matter. Now the counseling is going on. Your lordship, can you take up it on Monday, my lord, your lordship? So,
no, advancing what?
The date of hearing of the writ petition. I filed the challenge in the
The petition. We don't. You filed an application
Yes,
for
hearing.
Hearing?
Yes, my lord.
That will be considered next week sometime.
Obliged.
1 minute.
Lord, 13th is the counseling.
1 minute. Nothing happens, Mister. Even if counseling is held, nothing. You will not be hanged by neck, and it will not be a situation which cannot be. You are before us. Your interests are protected.
True that.
All these matters. I mean, you want a blanket stay of transfer and all this. This is not impermissible. This is impermissible. 13(9).
Obliged.
For application, Mister.
Yes.
Not final hearing.
Yeah, my lord.
13(9) for yeah.
Yes, I filed my 2 cases, my lord.
Yes.
Kind of correction, my lord. This matter came up on 28/8, my lord. I was directed.
What IA?
WA number.
No, what IA have you filed?
853, my lord, wherein I prayed for stay of elections, my lord. I was directed to submit the relevant rules of Red Cross, my lord, within 3 days on 28/3. Implying that I immediately submitted the relevant rules, my lord. That is not possible.
It has not come out. 13. Or 12.
Public, my lord.
Please, your lordships.
No, rules, and apart from that, you have to address us on the question of maintainability of the rate petition. I mean, then we will ask you, no, mister, we will ask you about the then maintainability of the rate petition. You will again seek a 3 days time to adjourn.
Yes, my lord.
Not going to do it.
Yes.
This all elections, etc. have been held.
Right.
You should have by now drafted the suit and had filed it. Yes.
My lord. That can be taken up with public.
Please, your lordship, this is mentioning regarding writ appeals, batch of.
No. We have stopped this thing out of list. This thing in list mention which number you are making a mention?
Out of list mentioning only. So this is a batch of 3 writ appeals pertaining to regularization, pertaining.
No, what do you want final hearing? You don't want final hearing by way of you file an app. You tell her, mister, you are an officer of the court, tell her what to do.
Much obliged, your lordship.
File an application for early hearing, madam. Every day we have to repeat.
Lordship,
We
fine.
don't fix the date of final hearing of cases by mention memos, right?
Lordship, the matter was last listed in July. Thereafter, it has never come up. Okay. Much obliged, your lordship. I'll follow for it.
No. Your matter is of which year, madam?
2020.
So what do you feel every week it should be listed? No, July it is listed, so August it should come, then September it should come. No, there are no cases in the High Court.
There are your lordship.
There,
I'll oblige, your lordship. Much obliged.
May I please, Your Lordship? 2 matters for stay vacate applications, please. Only
every day you vacate this thing, you are the council who always vacate petitions, right? Earlier also 3 cases, that's how we identify.
yes, only for the purpose of stay vacate. 2018 SRPC matter. 2018 SRPC matters.
2000?
18 minutes.
When did you file the application for vacate?
It is filed in between 19 to 20 minutes in 2 matters.
14th and 15th.
Much of time.
Which one you want on 14th? Give that first.
I have given plus 2018. Much of it.
Yes.
Lordship, trial court is not proceeding with the matter despite stay not being in operation since July. Your lordship has ordered a notice and then but date of listing was not given. So I just want a date of listing for that.
Which case? Where is the mention memo?
Lordship,
Memo, it orally it can't happen.
I have
That's what we are asking.
so actual notice is ordered, but date of listing was not mentioned on that in that order. So I'll
We don't mention the date, but which date do you want?
Monday or it was a 2017 trial matter.
You are staying in Hyderabad only, right? No difficulty in coming to the court on 15/9.
May I please, Your Lordship?
While my job renewal case was pending in that single level things. That
Huh?
responded to total by Q1, and they removed my all items.
The writ petition is of which year? Writ petition is of which year?
With that, 1139.
Huh?
It's a direct.
No. Writ appeal is of which year? How long it is pending?
Recently, I filed back. 6 months ago. 2009.
Ask him, mister, what is it? Brother, ask him what is, he wants the orders on IA or final hearing of writ appeal? So you attack to registrar judicial, there is a judicial order against you. Again you stand up. So 15 days ago also you stood up to take advantage. Filing interlocutory application against order of division bench amounts to contempt. Right? There is an order. You don't, this is again trying to mislead the court, is again a contempt, number 1. Then filing application despite an order that you will not do interlocutory application will be entertained. Some bench had passed an order against you, correct?
This is a writ appeal non-service. That is a writ appeal service order. That is a different thing.
You meet registrar judicial and convince him if there is no order banning you, it will only IA will come up. That's we are clarifying. You tell him. Yes.
Your Lordship,
Writ appeal 740 of 2020, I'm seeking an extension of stay. The writ appeal was supposed to be listed on 6th, your lordship has not been listed. My request to be listed on Monday for extension.
Who's supposed to be, who gave the date? You gave the date?
I apologize, your lordship. The honorable court only had the director listing the matter on 6th, your lordship.
You are trying to say that despite court order, the case was not listed.
Yes, your lordship.
See, mister, it's a serious matter. We will take corrective measures. It's a serious issue.
My review may be taken apart.
We said Monday, mister. You amend the petition, that's what we only said. Recall cannot happen. Recall means that you will have to argue that we do not have jurisdiction to pass an order on your petition. Then the question is, why in the first place have you filed a petition? If you think that we don't have jurisdiction. Then understand, mister, you are sufficiently senior person. We are sure that you are more than 25 years of practice. Then please take this opportunity to know the distinction between review and recall. These are words of different connotation. And you have an excellent library. Just inaugurate. Please go there and study what is review, what is recall. Next. Monday we said, mister. What will happen to your application is a different thing. But we are telling you, but understand the distinction. Recall does not lie, I must say, until unless you argue. Yes.
Before.
No, nothing. You are on debate.
Yes, my lord. But my name is not printed. I was not ready, your lordship.
No, can we hear him on admission? He has to argue on admission first. Yes.
But two writ petitions were not clubbed together and a common order was passed by the learned the judge. But where
No, Mr. Your writ petition has been allowed despite that you have filed this appeal. How?
only so far as directly,
How are you agreed?
only but the consequential direction that I am agreed, my lord.
Consequential direction, the court itself should have corrected entry in Patta passbook by your own hand.
My lord,
What is this,
the
Mr.?
court, the learned Singh judgment allowed the writ petition.
Nothing but that you are not an agreed person by the, your writ petition has been allowed.
True, my lord. Writ petition was allowed.
Then
Having allowed that.
this is taking things too far. That despite we would have understood that you file an intra-court appeal, so judge does not grant stay. You are not a party to an interim order, then you file intra-court appeal. Your petition is dismissed, you file intra-court appeal. That is understandable. If the judge allows the petition despite you are not an agreed person, in our opinion, you can approach the single court, single bench, whatever you want, direction, whatever. It does not lie according to us.
Last may observe that. Last may kind of grant liberty to my lord.
There is no question of liberty. We are deciding this writ appeal. You are at liberty to file. In this writ appeal, this intra-court appeal has been filed.
Yes.
Let the petition, number 2, let the petition be listed before a bench in which one of us write his lordship's name is not a member. Next. Sorry, 2 is done, madam. Next.
Post before
It-
another bench.
Don't tell us. Post.
Allowed.
You cannot pass an order, right? Post before another bench. Can you? Can you pass an order in this writ petition? You said, is this the submission? Standing up and saying post before without any prefix. You are not even addressing her and directly saying post before another bench. We refuse to dictate this order, which you have just now told us. What will you do now?
I'm sorry.
No, Mr. You cannot dictate the order. Remember? 3. Yes.
May please, your lordships. In item number 3,
I have not heard item number 3.
yes, madam. I'm appearing.
He is still standing. You did not call. You handed over the file to us.
I'm sorry.
Yes.
The writ appeal has been filed against the Leonard Single Judge's order dated 12/6/2023. In confirming the order passed by
Also, the Tehsildar had entered the names of Mr. Ramarao and his family members without notice to respondent 5 to 12.
yes,
Contrary to section 5 of the act. Therefore, it has been held that the joint collector has rightly ordered correction of entries and restoration of same prior to 2005.
in fact, you lordships entered a writ appeal against the very same order.
Which writ appeal?
Writ appeal 765 of 2023.
List along with item number, list along with WA 765 bar 2023.
Wherein lordship granted interim suspension of the order.
We don't know. We don't know. We will list it along with that writ appeal.
Yes,
There is no question, there is condemnation of delay
yes,
in your appeal. Next week, madam.
yes.
List along with WA number 88, whatever number I have told in the next week.
Yes.
On Tuesday, you write. On Tuesday.
Tuesday.
Yes.
Oblige.
Which rule you are entitled?
I'm
Additional quantum of pension under which rule you are entitled?
I'm relying on the GYMS number 57, my lord, issued by the state government.
Which, where have you annexed?
I had filed it along with the writ petition, my lord. It is at page number 16, my lord.
16.
Yes, my lord.
What is the provision? Yes.
Normally, all the High Court staff are eligible for the benefits on par with the state government employees, my lord, unless the Honorable Chief Justice passes any particular order, my lord. Accordingly, I'm relying on GOMS number 57, my lord, issued by the state government.
We asked you under which provision you are entitled.
Pensionary benefits, my lord.
Ask him.
I'll state the rule, specific rule, my lords may kindly pass a.
Learned counsel for the petitioner prays for adjournment to enable him to the petition without even examining the question of entitlement, without producing the rule, just like that. Yes. Yes, Mr. Examine it. They need to challenge the rule, but you examine state government.
Hello, I'm representing High Court. This is regarding medical reimbursement, item 5.
No, you are petitioner.
I'm representing the respondent, High Court.
I am the petitioner.
That's why I told you.
I am the petitioner, Lordship.
So you are not challenging the rule which confines the your entitlement to only 1 lakh. Then only you can get the relief. Otherwise, how can this court grant relief contrary to a statutory rule? Do you understand, counsel? Please amend the petition.
With great respect, Lordship. In fact, earlier similar batch writ petitions were filed at page 18. Your Lordship would kindly take. page 18, Your Lordship.
Ah,
8. Where, Your Lordship, page 19, if I'm permitted to read.
it has been allowed, right?
Yes, Your Lordship. By referring to an earlier.
Fine, so with same order. Heard on the question mark, who is appearing, petition is admitted for hearing with consent of the parties. The matter is heard finally. In this writ petition. One three AIR 87 Who appears for university? Huh. These people stand up, Mr. Rao, so we are unable to see you. All the time. We have instructed them before 10:30 should stand up, and between 1:30 to 2:30 and after 4:30 they all stand up. Yes. So he can furnish, right, bank guarantee in terms of. That's correct. The question is only of furnishing bank guarantee.
She did not join. No, for joining only, when I have gone and submitting all the securities, they are not taking me. Demanding me to.
Let him.
Fact is, she did not join.
Let her go tomorrow and furnish a bank guarantee in terms of GO dated 12/8 within 1 month. Shall we dispose it of or?
That's what it is.
Mark the presence with consent of the parties, the matter.
Same letter.
All right. It is the key paragraph. It is the case of the petitioner that in terms of GOMS issued by government of Telangana, the petitioner can furnish the bank guarantee within a period of 1 month. However, the pleading. First you implead, Mr. Make correction.
I will complete.
That we understand. You need not make a prayer copy by today. These people would do it even when we don't say. They know. They are more sensitive than you.
It's true, man. Highly obliged.
True, no? Yes.
Below problems.
Petition file, Millard, seeking the
Pending.
representation is pending.
Which page?
Millard, page 12, Millard.
Yes, Mr. Rao.
Millard, petitioner also, a student, Millard, he got a seat, Millard, but unfortunately could not join there. Second phase also he could not join because Millard, map of ground counseling commences from tomorrow onwards. Tomorrow he has to go to Monday. He may permitted to Millard, exercise options in third phase of counseling. No representation, Millard, Lakshmi will give a direction.
Even if as
Permitting him to,
within the knowledge
Nobody, why he did not this thing?
already Lakshmi kindly see, he according to the affidavit government, he got admission in Government Medical College, not Karimnagar.
would clearly
But
demonstrate.
considering the distance, he could not join there. Second phase of counseling, he got Millard Solvik Medical College as far as the merit. Solvik Medical College is not a government college. The petitioner.
No, so supposing if a person is at allotted seats, he can give up and still participate in mop-up round.
No, unless he has to join, but he will not be permitted second round. Further round.
And you are saying that
And if at all
that he has been allotted seats, but still he should be permitted. How?
the affected party
Mop-up round.
Allotted, but because
Has
it
been-
happened to be
has
a
been given.
private medical college,
The
he is
company-
not, he is financially
So what is
capable.
the rule then? If supposing if he has been allotted the,
the facility
he has to give up.
He will not be permitted to participate in the further round of counseling as it is
CDR.
causing seat blank.
But
Then you are
India's
just now you said that he be
affected by
permitted to participate.
Because of the total, that is only without my submission.
Why you did
And they will
not,
be given
you are allotted
70%
seats,
of
why
the
you
areas
didn't admit?
surrendered.
Private, Millard, we did mistaken impression that Millard it's a,
No, everybody is a mistaken impression, right?
it's a government
No,
college.
first round, where did you, Mr. Where you tell us first round?
Millard, Government Medical College, Karimnagar, Millard.
When? First round of counseling held when?
Millard, it's dated Millard, 26/8/2023. I'm sorry, Millard.
Huh?
But 3rd August to 6th August.
He participated.
Yes. But he was allotted seat.
Allotted seat in,
Page 18, Millard is the.
see what a pity, Mr. Rao. You are required to tell the what are the facts. Petitioner doesn't know. The client should, this client should see the performance of advocates.
Dates, Millard.
Allotted in, seat in,
Government medical college, Karimnagar.
don't, now, if we had given you the chance, you were turning pages here. That means it has been drafted by somebody else and you did not even care to read it before standing here. That's the impression.
I said page 18.
But wait. Allotted seat in Government Medical College,
Karimnagar, Millard.
Karimnagar.
Millard, the second phase of counseling, Millard, he was allotted seat,
He did not join, right?
He did not.
Second,
Sorabi Institute of Medical Sciences, Siddipet.
when it was held second round of counseling,
Second round, the allotment is 3/9/2023. 3/9/2023.
he was allotted a seat in
Sorabi
Surabhi,
Institute of Medical Sciences, Siddipet.
Surabhi Institute of Medical Sciences, Siddipet.
But it is a private medical college.
Fine.
Fees will be more than.
No, that's correct. So he did not join. Right.
He did not join, he wanted Millard the permission for.
All right. So then this petition has been filed on with 5/9. What is the prayer?
Only consider representation. That will not work out to his benefit, lordships.
Mandamus. Third round of counseling is going to be held on
Millard, they give tomorrow, Millard, I'm told, tomorrow,
8/9.
9/9. Up to Monday, Millard, web options have to be exercised.
Up to 9/9 to 11/9. which is the provision which says that according to your rules,
JMS number
that if a candidate has participated in a one round of counseling and has been allotted seat, he is entitled to participate in further rounds.
that the admission rule says so. But if it failed, but one GMS number 125 and 126.
Where is?
But I do not have the copy. GMS number 125 says, Milord, if a candidate is allotted to a seat, Milord,
See, Mr. Rao, it is so easy nowadays. Practice has become file everything, obtain a mention memo. The court itself will find out what are the facts. Court will ask the counsel for university what is the GOMS and decide pass an order. And then only at the end of you say CC today. How easy it has become. I wish when I was at that side, the life would have been so easy. I would have never crossed over. I really tell you. With all, none of us would have crossed to this side and do all this. See how easy the life is. File anything, whatever. Don't read the petition also. Stand up, court will do itself. Because what is his answer is, you have taken oath to do justice, do justice.
Because a student, Milord.
No, that's his stand, that I am not required to study anything. I will not assist the court. You have taken oath to do justice, you do justice. This is, so where is GOMS 125?
Not file, Milord, I do not, right now I do not have the copy, Lord.
Then file a copy. We will have to see his entitlement. Which rule you are entitled to this thing? Two rounds you have been allotted seats. How are you entitled to participate in third round under which provision?
As per rules, I am not entitled, Milord. That's the reason.
Then how this?
Milord, I made it.
Then whether in exercise of powers under Article 226, this court will grant you a relief which is contrary to rules? Ask yourself this question, you will find the answer. So we will say, why to adjourn his, prolong his agony, let him go. The
Student, Milord.
towards, no, he can go northwards, no, travel. We will give him certified copy today itself. Thank you. Under rules, you are not entitled, right? Fine. Yes. In this writ, mark the presence with consent of the parties, the matter is heard finally. In this writ petition, the petitioner who is an aspirant seeking admission to MBBS-BDS course for academic
her options in the second phase, Millard, because the family had a conjunctivitis.
No.
Time.
This is a petition challenging the virus of rule.
No, Millard, this is Millard.
Virus.
Earlier, Millard, she has filed Millard challenging the virus of 72. Now, Millard, the peculiar circumstance is that she was not able to.
This is not rule 32H, right?
Yes, Millard.
Not 32H.
3H, Millard.
Yes. Not at that.
Millard, I made a representation. Millard.
What she allotted a seat?
No, she was not. Andhra student. Andhra student, Millard, she was not allotted a seat in the first phase. Second phase, Millard, she was not able to exercise her options because she was suffering from conjunctivitis. So, Millard, she will not be allowed to exercise her options in third phase. I made a representation, Millard, to consider her.
First, Mr. Rao, you should have the rules, right? We cannot one after the other. We will have it on Monday. You find out what is the position. But it is not a case of allotment. And see if in that son's case you get the GMS, please give it to us. We will mention it. And Madam, certified copy today, all cases medical admission. So this you produce the rule. On the question of admission notice. Earlier case UMS number 75 dated previous case 125 dated 22/9.
He or she shall not be eligible for further rounds of counseling.
Millard, first phase.
So she has not indicated. You file an affidavit.
Millard,
You have you indicated, madam? Where have you in that first phase of counseling?
Yes, Millard.
You had indicated the option.
Yes, Millard.
Where is that statement on affidavit? Which paragraph of the petition? Give a printout, Mr. Rao. Printout. And previous also, Mr. Rao. Previous case also you gave the printout of the rule.
Same rule. I will give.
Millard,
Which paragraph?
paragraph 6, Millard. I have said, Millard, I submitted the page 9, Millard.
9. Yes.
I submit that the respondent has declared the results of the first phase of counseling. The petitioner did not obtain a seat in the 20 medical colleges. She has exercised.
Please read. Probably you have not, that's why you have not annexed the rules because you know that they are against you.
Millard, no, Millard, I have.
Where is the petition? Where are the rules, madam, under which you are claiming participation? How sketchy petitions are filed like this?
Millard, she has, Millard, exercised her option in the first phase, Millard. Second phase.
Please, madam.
Yes.
The prayer is that you want a direction to them to permit her to participate in this thing.
Third phase, Millard.
Third phase.
Third
Map round.
Yes.
Under which provision of law you are entitled to participate? Simple thing, because this court will enforce the statutory obligation and a statutory right.
Millard, the rule mentions, Millard,
There is no rule.
Millard, the rule just now read out, Millard, by my.
You are petitioner, madam. He is not petitioner. And we cannot, this thing, you are a sufficiently senior person, right? That, in that case, he was a young person who had not read the file also. So therefore but we cannot expect this from you. You are,
I'm sorry.
you should be, I mean, you should have annexed the rule, said that under this rule I am entitled to participate. We would have immediately.
Millard, in
But
fact,
see, just like filing petitions casually without this thing, how can we do it?
in fact, Millard,
We don't have such power to do whatever we feel like. We are bound by rules. If under rules you are entitled, you will get it. Not entitled, not get it. Learned counsel for the petitioner prays for adjournment to enable her to place on record. No, but they know that the rules deliberately, but you then not see that once to try and read about. With that, petition is admitted for hearing notice.
What's your pleasure? Consideration of representation.
Which page, Mr.
Page 33.
Huh?
Page 33 order merit acts. Page 30.
30?
33 merit.
Right, madam. Page 33. Certified copy today. We believe that. Before 1:30 you will give it, so brother signs it. Not at 4:45. Or you go, send somebody so that you can type.
May I please, Millard? Same order, Lordship. Page 22.
Page 22.
No, Millard, this is different.
No, different.
This is not a
what is
petition, Millard. This is, the petitioners in this lordship is a disabled persons working in the respondents department as a teachers, Millard. And Millard,
He has challenged Mr. Rao.
sorry, Lordship.
Validity of rule that he was right in saying.
Yes, Millard. Lordship. And this issue is already settled by this court, Millard.
Admitted for hearing notice.
Millard, one second, Millard. Millard, already this issue is settled by this division bench of this court, Millard. On 2nd August, division bench of this court passed an order striking down the 70% disability, Millard. Lordship may permit to read the judgment copy at page number.
No, Mr. Despite that, respondents have to be put to notice.
Millard,
It cannot be, it is allowed therefore.
Millard,
That therefore you have filed without notice to them first day, we should allow. This is not the law.
Millard,
They have to be put to notice. We are putting them to notice. You can find it out on the next date of hearing. Learn it.
Monday, Millard, Monday. Lordship, because Millard, the transfers and promotions are going on, the petitioners will be deprived of their opportunity to get promotions, Millard. But and the issue is already settled. My Lordship may permit to read the judgment of this honorable court. First and second.
No, that's why you have a good case. That is why we are admitting it.
Millard. If it is adjourned, Millard, the transfers, promotions may.
What is
In
the
that
law?
case, in that case, Millard, Lordship may.
Is it a death penalty that person cannot be brought back to this world?
Right.
What is your client is facing death penalty today at 2 o'clock. He will be hanged so that if we issue notice, he cannot be brought back to this world.
Millard.
That
Since Millard, that schedule is released.
No, Mr. Show us the law that if a similarly situated petition has been allowed, the subsequent petition should be allowed on the same date without notice to respondents, without giving them an opportunity of being heard. Either he should say it is covered, then in that case we will. He is standing looking at us.
Yes, correct.
His job is to look at us.
Not covered yet.
That is for allotment of local cadre jobs. Is transfer.
Mr. Praveen Kumar, they are all your colleagues. Ask them to improve, right? These, especially this council, we have not heard his voice so long. I am here for seventh week. He only stands up and looks at us. We don't know.
It is not covered, Your Lordship. Your Lordship was
It must be, I wish that I hope that it must be a beautiful sight to see us in action. But he looks at us and just standing like waiting.
Lordship was stated.
So the court should do it on its own, and he doesn't say anything. If the court has to grant time, it will grant time. It has to dismiss, it should. But he's standing here. Please explain it to him. Mister, he's your colleague, right? Huh? Please explain it to him that he's standing here not to look at us, but to assist us as an officer of the court. Will you please tell him? It's a
My last submission, a simple stay may be granted, I filed an IA. Already counseling has been commenced, Your Lordship. Transfer issue, Lordship. Seeking stay of all transfers, Your Lordship. Moreover, GO issued in 22, Your Lordship. GO issued in 22. Now he challenged, Lordship. 23. GO is dated 25/1/23, Your Lordship. This transfer counseling, Your Lordship. Now, entire process has been commenced, Your Lordship. For submission of application also dated 4, Your Lordship.
So, Mr. This GOMS was issued on 25/1/2023.
Yes, ma'am.
You are saying that this writ petition should be allowed today. So before that, we will ask you, what have you done for 7 months? Tell us. You want the petition to be allowed today. What have you done 7 months? This GOMS was issued on 25/1/2023.
Due to the recent judgment of this court, petitioners have.
You are a fence sitter, right? Fence sitter, watching others to fight, and the moment you knew that they have succeeded, so same principle. Delay and latches. Why? This is, we are invoking just to tell you that it is not that imminently urgent as you consider. It cannot be allowed today, and no stay can be granted.
Maybe short date, maybe.
Yes,
Lordship. My final submission, my lord, I leave it to Lordship. Short date, maybe.
Third, on the question of admission, the petitioner in this petition has asserted the validity of guideline number 7 within brackets small a of GOMS number 5 dated Page 22, certified copy today.
Public. Manas, petition is offering challenging.
Satyavati Tandon.
Manas, offering challenge to the notice invoked by R2 under section 30.
No, which R2, Republic Day.
No, extremely sorry, Milord. I'll correct myself. Sridham should finance, Milord. Sridham should finance. But under section 13, subclass 4 of Surface Act, to take the position.
Against the aforesaid order and appeal lies.
Now, here for a moment. Now, the factual matter is that neither I'm a borrower or a guarantor. Neither I'm a borrower or a guarantor. But I cannot go to DRT. But the facts are like so. But
Section 17. Have you ever read? Have you ever read?
Even a part of the book also,
read section 17. It says that only a borrower and guarantor can go or anybody can go.
It doesn't say about
section 17.
Milord.
We are asking you to read section 17 and then show hands like this. We are not at the traffic junction, right? We are not speeding, so you show hand.
Tribunal shall exercise out from the appointed day the jurisdiction powers and authority to
Surface Act. Section 17 Surface Act. You are reading something else.
I'm reading the
unfortunate, Mr. That statutory provision also you cannot read. Unfortunate. We will read it for ourselves. Yes. Yes. Any person, including borrower. Any person, not borrower, guarantor. Any person means any person. These people know. Yes. Anything else, Mr.
Provides the remedy of the appeal for the borrowers against the action taken banker.
If that is your understanding.
Any agreed person, what Malas have said, any agreed person. But here, I'm just trying to bring to Malas notice that neither I am borrower or a guarantor.
We have understood, right? We have answered that. We have understood, therefore, remedy of appeal is not there available to you, and therefore, writ jurisdiction should be exercised and money should be ordered to be refunded to you because you hold an agreement of sale.
But it is not like so, Mira.
Like we are saying, Mr. We have understood we have read the file, that's why. You have not probably read section 17.
It is not my case, so Mira. I'll also appreciate for a moment. Mira. Lord, may I? Lord, respondent number 1 avails a loan from the respondent number 2, that is a banker. Lord, he defaults. Lord, I have not borrowed even a single pipe from the respondent number 2. But despite I got the notice of the respondent number 2, it is the respondent number 1 was taken the loan. Now, Lord, respondent number 1, respondent number 2 is coming on the property, my Lord.
We thought that people have stopped filing writ petitions, but still people are coming. This is an order, our order which binds us, right? And not our order, Supreme United Bank of India versus Satyavati Tandon and Vari Madhu O.B. Reddy versus.
May I just try my level best to better my case for a moment? If my not permit so, I'll take Balas to the judgment of Honorable Apex Court, wherein the Honorable Apex Court has said, yes, jurisdiction is very low, but in peculiar facts, it can be done so. If Panar permits, I'll just purport the judgments. Can I pass the copy of it?
Of course, you have a right to argue. Argue sense, not anything else. And we are under an obligation to hear, but we will only hear you so long as you talk sense. First of all, plus, have you read Satyavati Tandon? Satyavati Tandon. Then whether Satyavati Tandon has been considered in this judgment? This is an incomplete.
Page number 12,
1 minute.
Union Bank of India versus Satyavati Tandon.
Yes. Which
Madam.
page?
Page number 12.
12. Yes. Yes, yes.
By your statement, the appointed parties will recasted.
No, what is Mr. What are the facts of this case? What is the ratio?
The ratio is that the notice and the settlement that is sub class 4 is amenable to section 70 of Surface Act.
Extraordinary circumstance. What is it? What Mr. Extraordinary circumstances? Satyavati Tandon itself says. What are extraordinary circumstances in your case?
Here, the case is that respondent number 1 takes the money from my property. I'm neither the borrower nor the guarantor. But even to go to Surface Act, what may also said any additional time to this DRT, having so,
We do not say sections is parliament says so.
statute says so, but having said so, having here, they don't fall under the purview of debt, my lord. The loan amount which is supposed to pay by respondent number 1, but does not fall under the purview of debt. Even to go to DRT, my lord, I have not taken any money from the respondent number 2. But that is what I'm just trying to bring my lord's notice that exception case, my lord. Not more than that. If my lord says that I have only remedy to go to Surface Act, my lord may give that observation, I'll go to Surface, I'll go to DRT court.
We are holding so. This is the order. We thought that entire bar knows this order by now because it mentioning state itself we are passing that order. So people have stopped filing because and they do go to DRT.
Page number 80 for a moment.
What is his name? We are holding. You said you hold so. We are holding so. Yes. In this petition. Yes, madam.
For a moment. Page number 18 for a moment. I will take my lord to particular matter for a moment. 18 says, by doing so, we are conscious of the fact powers conferred under Article 226 of the Constitution.
Powers under Article 226 are extraordinary, discretionary in nature. And nobody can compel us to exercise the discretion.
So, in a commercial matter involving a lender and borrower, but I'm not a borrower. Who is the respondent number 2 is a lender?
You have told us time. That doesn't mean that if you are not agreeing, you will keep on repeating it.
I leave up to this court.
Fine, thank you.
At least Manas may give.
Argued well. Yes.
Manas may give some breathing time.
No breathing time.
But 1 week from today to go to Surface Court, Surface DRT court.
You go to wherever you want to go. Nobody prevents you. Yes.
If Manas stays the notice for 1 week.
No stay. It is not the forum. Mr. See, hundreds of cases come to us. If we grant stay in one case, every case we have to grant stay. You know, people, what they will do is like you will file the petition and say, sir, 1 week, sir, stay 2 weeks, and then I will go to the RT. So without anything, they will get stay.
In this court, articles by the Supreme Court for challenging the 30 Subclass 8 notice, wherein the Apex Court has said it is not clear.
You file SLP. We are passing an order today. Yes. Fine. Then don't say this thing. File SLP. Yes. In this petition under article, and don't say that ask me to file SLP. We are deciding the matter on merits, mister, by relying on your judgment, because see, we have to be very cautious. Otherwise, people say that I am filing SLP or filing an amendment because court directed me to do so. Not like that. Huh? Do whatever.
But one word.
Yes. In this petition.
I just pass another judgment if one permits so. In a case,
don't, mister, we have told you have the right to do so. Just now you said that please hold that I have a remedy of appeal. We are passing an order. You said it. Like you should say that I am still to argue. Then why did you say that? Hold that?
I'll withdraw the vote. I'll withdraw the vote. I'll withdraw it.
Withdraw the book.
Withdraw the vote. Not to hear me on the other aspect.
Yes, I think, what?
Withdraw the vote.
He needs to withdraw the word. Withdraw the word. We heard word. So I was confused what word you are withdrawing. Ah, yes.
One judgment is for pass out.
South Indian Bank.
Just
First submission is that you are neither a borrower nor a guarantor. Second is extraordinary circumstance as pointed in South Indian Bank. Third is
case of Vikram Kumar, the State Bank of Hyderabad, where an SFB was carried.
yes, which para?
5.1 million,
Hmm? Para?
5.1.
Yes.
It says that, still we are not assured whether 13 subclass 8 or 13 subclass 8 notice is amenable to rejudication
Paragraph 5.1 is what? It is submission of the council. In this case, for your information, you have challenged the notice under 13.4. It's not 13.8.
That's what I said, 13 subclass 8.
This is not your case is not involving 13.8. You have challenged the notice under 13.4. So how is it? Please tell us how this case is relevant.
I will bring to my last story that tomorrow subclass 4 will be followed by subclass 8. At least I will have the remedy not to come to this court if not
We don't know. With you, when you will come, we will see. Decide it at that point of time. We don't have this thing. Anything else? Yes. In this writ petition, certified copy today. Small concession is only that. Yes.
Appeal from today, my lord, within 30 days, appeal has to file. Or else I need to go with the delay application.
Go with delay.
Delay.
We are not responsible, right?
At least
We did not advise your client to file a rate petition.
today, my lord.
Yes. If it is one of the limitation, we will pay the discount group should bring to the get from the nation bill. Yes.
My lords, I am representing Mr. Anup Kaushik Arwadi. I am representing Mr. Anup Kaushik Arwadi. The petition, my lord, seeking to consider the
Registration, my lord, the order copy not enclosed, ordering page item 1112 last.
Well,
consideration of representation for registration, B category and C category.
Where is the order?
Order is not enclosed, but order copying item 12 last. Today's
Item 12, that's a similar order, right?
Last.
Consent of parties heard finally certified copy.
Item 7, your last was pleased to direct me to produce the GO admission rules.
Give. With
admission rules.
Which rule, Mr.?
The rule 4, Roman 4 last.
Roman 4.
May I read last? Page 7, bottom. Candidates are permitted to top lot. Candidates are permitted to exercise web options for each round of counseling separately. While submitting options, candidates have to give options the course and college in which they are interested. Candidates are not supposed to give options to the courses and colleges which are not interested. There is no limitation for options. If the candidates are allotted seat, he has to report admission without fee. If the candidate has not reported, he will not be considered allotment.
What we have said, no, admittedly under so and so. Before that one paragraph, madam. No. Fairly submitted just before that one paragraph. Rule 3.
4.
No. Rule 4. Within bracket, Roman small 4 of Telangana Medical and Dental College admission into MBBS and BDS courses, rules 2017, reads as under.
I was happy for a petition on this one.
This is 2017 rules, right? We have done it in that bunch. Yes.
I was happy for a petition on this matter.
Madam, what is it?
My lord, this is a matter in which there is a.
Challenge the order passed dated 5/7/23 passed by DRT. So what happens to section 18, madam?
My lords, my only submission is that this
No, no,
matter is.
18 appeal lies before appellate tribunal.
Understand, my lords, this.
No.
My submission is.
Understand is not fine. Appeal lies or not?
It lies, my.
Then what does Satyavati judge bench of Satyavati Tandon says?
My.
Do you want that the Supreme Court should again deprecate us for entertaining the petition?
Not at all, my lords. My submission is just that this is one of the few exceptional cases in which the revisional jurisdiction of this court would apply under 227 of the Constitution, my lords.
27?
Yes, my.
26.
No, my lords, revisionary jurisdiction and
There is no
supervisory
revision.
jurisdiction under 227, my lords, which my lords has also relied on in the past, which is a Shalini Sham Shetty judgment of the Supreme Court, my lords, 2010 Supreme Court. I can pass on copies also, my lords. If I may just make one submission of the order, my lords, this is a matter in which there is a moratorium.
But it won't like this. Same principle. Ask why Satyavati Tandon won't apply.
Why the Satyavati Tandon case won't apply in this case?
My lords, my only submission is that.
No.
The
Answer the query, madam.
My lords, I'm not disputing that an appeal would lie. An appeal would normally lie, my lords, but my only submission is that the supervisory jurisdiction which can be exercised at the discretion of this honorable court is applicable in this case only because there was a moratorium against the company because the company was admitted into CIRP by the NCLT. That order was brought to the notice of the DRT, and as my lords are already aware, there is.
Yes. Say I don't have money, then we just view from windows. This ending before the NCLT. Maybe probably SBI or the agreement resolution professional there are two continuing proceedings. One is before the DRT, the NCLT. Calcutta is a good place, pattern.
My lords, just one submission, my lords.
Calcutta, no, you will have to go to Calcutta.
Just one submission.
It's a good place.
I don't dispute that, my lords. Just one submission, my lords, that the impugned order is perverse, my lords, in the fact that there is a moratorium and no proceedings can continue. By operation of law itself, these DRT proceedings cannot continue against the.
I'll review. If it is error apparent on the face of the record, jurisdictional infirmity, file review. That remedy is not taken up.
That remedy is not taken up.
Then you file that or do whatever appeal. You advise, madam. We will not advise your client what to do. What we are simply saying is 3-judge bench of Honorable Supreme Court in Satyavati Tandon binds us.
And this only submission I had was on revision, but I leave it to madam.
That is all right. 227. But Satyavati Tandon will. That's why brother asked you a question. Why Satyavati Tandon won't apply? You are not saying no.
My lords, I cannot make that submission.
Right? Everybody has to. Then as a counsel and as an officer of the court, don't argue, madam. You are a young person. You have argued well. We are advising you, right? Never argue contrary to a Supreme Court decision.
My lords, I was only arguing this to the extent that Supreme Court itself has created this exclusion in cases
Nothing.
orders for.
Yes.
Only these
In
kinds
this petition. Where is that Satyavati Tandon, madam? In this petition filed under Article 227 of the Constitution of India, the petitioner has asserted the validity of the order dated 5/7/2023 passed by Debt Recovery Tribunal in an appeal under Section 17 of the SARFAESI Act. Paragraph. Learned counsel for the petitioner clearly has not disputed that against an appeal against the aforesaid order, an appeal under Section 18 of the SARFAESI Act lies before the Debt Recovery Tribunal. However, it is submitted that the jurisdiction of that supervisory jurisdiction of this court can also be invoked under Article 227 of the Constitution of India. Paragraph. We have considered this submission. CRP means civil revision petition. So how does it lie against an interlocutory order in view of proviso 215? Madam,
My lord, under the.
you have what we have understood is that I really don't know how it is, but here it is. You have written under Article 227 of the Constitution of India.
Divisionary jurisdiction of.
No, madam.
27, my lords.
Then why are you saying that civil revision petition? This is a writ petition.
My lords, there's a Supreme.
No, madam, this is all frivolous and cannot go on. You cannot file a civil revision petition is a distinct remedy under 115 of Code of Civil Procedure. 227 is 100. It's altogether a different remedy. You cannot file simultaneously one petition and say it is under Article 226 or 115.
No, my lords, I said under Article 227.
Then we are writing it writ petition. Why are you saying that it's a revision petition? Madam, come to page 2. So it's a petition under Article 227. I don't understand this nomenclature, madam. CRP. But I'm saying we are treating it as a writ petition under Article 227 and deciding it. So under which provision this order has been passed?
The impugned order.
Of course.
The impugned order has not been passed under any provision as such, my lords. I just brought the NCLT order to the notice of the DRT.
Madam, we said you said that appeal lies before 93 Act. Now you are saying under what provision? Which? How we proceed?
Any order of the DRT is appealable under the RTDB Act, my lords, under Section 20. Appeal to the appellate tribunal and to the RT.
Order. Tribunal under Section 19. This order is under Section 19. Right. Yes, madam. Right. Read the first opening paragraph. correcting us. We thought that it's surfacing.
Your Lordship, and so far as item 16 is concerned, Your Lordship, the writ petition was filed for disposal of the representation. And so far as sale of idols for 2022, my lord. So, as on today, Your Lordship, the representation was specific only with regarding to sale of 2000 idols which were made before Corona period, my lord. So that interim orders were passed, Your Lordship. So nothing survives now for this year, Your Lordship.
Interim order?
Interim order, Your Lordship, was passed by this honorable court on 21st July, my lord.
No, so what do you want? This
Nothing
is for
survives
admission.
in this writ petition. Nothing survives now in this writ petition, Your Lordship, because item 17 goes on. 16,
17,
nothing. Yes.
16.
16 does not survive.
All right. Learned counsel for the petitioner submits.
This guideline, revised guideline 2 fell for consideration before the National Grain Tribunal, my lord. An appeal filed with the Supreme Court was also rejected. Thereafter, my lord, the writ petition, public interest writ petition filed before the Bombay High Court, my lord, it was taken note of these orders passed by the National Grain Tribunal. This revised guideline was subject matter of the NGT. And also,
it has been appealed by Bombay High Court.
Bombay High Court also appeal before Supreme Court also rejected.
No. Mr. That's fine. We will hear you. You have given a synopsis. Very good. But question is whether have you seen the judgment of Bombay High Court?
Yes,
You have examined, no?
Yes. Lord, so far,
yes,
no finding is given insofar as the validity of guideline number 2, which absolutely.
Please argue. Like now you have to. We are hearing it finally or what, Mr. Prasad?
Yes.
I have passed.
Hearing finally.
I have now relied on the judgments of this NGT and the Bombay High Court for this purpose that the revised guideline.
No, correct. We have to. How much time will it take, Mr.
It will take 40 minutes, 45 minutes.
45 minutes. No, nothing 45 minutes. You have given synopsis. Such a beautiful synopsis, 10 minutes.
Synopsis.
Like contentions are
Contentions, I directly go. I also made a Milord list of.
Yeah, otherwise we will we fix it on some date, then hear it leisurely, like if you want to argue for 45 minutes. Some other day, October.
Yes.
October we will hear.
Meanwhile, we will vacate that order, Milord, which was passed in the last year, Milord, because that is coming in the way, Milord.
Which order? You have filed vacating stay?
Yes, ma'am.
Where is that? Who are you?
I am an intervener in this matter.
No. Intervener means who are you?
I implead petitioner, Milord. I respond number 10, Milord.
13%.
Yes.
You are an advocate.
Yes.
Acha. So why you want to implead?
Because already there is this coordinate bench order is there, Milord, directing the state to pass orders with respect of POP ideals, Milord. Already this honorable court has, Milord, applied this clause 2 of revised guidelines, Milord. That order is passed in in a public.
So there is no, which petition have you filed, Mr.?
No, I have
In
filed.
item 1 minute.
Yes.
16369, where is your vacate petition?
I have not filed vacate.
Then please, how can we orally see, Mr.
Already.
This
Not filed this condition.
1 minute, if there is a stay granted, firstly, we don't know if it is granted. It can be vacated only after hearing, not on an oral prayer like this. Supposing if you are petitioner and he makes an oral prayer and you vacate, what will you say? That's, sir, I'm entitled to at least notice in this thing. Please file an application if there is this thing. Which interim order is there?
Last year order, Millard, in the 19.
So this is operating for past 1 year, Mr. Advocate.
Yes.
And you did not come in time and you want.
I filed judgments for this honorable court.
No.
This
Please.
the coordinate bench overlooked the judgments, Millard.
Please.
Passed interim orders, Millard.
You have been heard right before passing the order dated 21/7/20.
That order, Millard.
Then how can you then?
I brought to the notice, not even the government.
No, this is Mr. Counsel, then you should realize once you have been heard, interim order has been granted after hearing you, your remedy lies in going to do number one. Secondly, if you want, then we have to hear. This is a bi-party order. You are well within in your this thing. Why we are not hearing is because we are sitting till 1:30 only today. So that's why we are fixing a date. So you can say that, sir, this be heard early, understandable. Just like taking chances that let's see if the court vacates on oral prayer.
File vacate.
You can't file, Mr. You can file, we can't prevent you because we are not in a position of in person where the direction has been given that he will not file any interlocutory application. Fortunately, you have not reached this stage, but you will be advised not to file because result is a foregone conclusion. Because you have been heard by passing the order dated 21/7/22. You didn't file vacate. I did not know this. So you can say that.
Filing is taken in this matter, no vacate statement is required in this matter because this matter is going to postpone for some other day.
No. This is not listed for final hearing, Mr. It's only for admission today. And challenge to the revised guidelines. Case is made out, we will have to examine it. And Mr. Prasad has told us that Bombay High Court has division bench has upheld the validity. That is pending before Supreme Court. We will have to take that into account. And we are sitting till. And what would like to.
What my learned friend saying that were already upheld by the Supreme Court, Millard. In the year
Orders passed from the NGT has been upheld by the Honorable Supreme Court, which is required in the division bench.
Mr. This is a challenge to revised guidelines.
Yes.
In this writ petition, the petitioner, which is an association of artisans, have a Why NGT was filed before Bombay High Court? No.
For this Honorable Supreme Court. Can you see the division bench order of the Bombay High Court?
Where is that?
I have pasted. I have just passed out.
It is further submitted that the order passed by that again. Or 3rd October, choice is yours.
3rd.
3rd October. Praise for
I may permitted to file vacate tomorrow, and it may be listed on Monday, because already the PO pages have been sold in the market, If again the PO pages for immersion in water bodies, it will be very damaged to the environment,
That's in the earlier division bench also, this Honorable Court was pleased to hold the reverse side of Tangman, the POP idols will be immersed in the baby ponds created by
Hey, Mr. C, by your conduct, how much of pressure you create, Mr. Counsel, on the court every day. See, we are dealing with the admission of MBBS matters bunch.
I can understand that.
But will you write judgment? If we can outsource, it's very easy, heard closed.
I'll leave it, brother.
Vacate petition, what will be the result? You know it, because the interim order has been passed by hearing you. That's the order. Do you want that we should say that oral submission has been made? It is rejected. Because oral submission is not this thing. Interim order has been passed after affording opportunity of hearing to all of you, that you have been heard. And despite that, a division bench has granted an order. Looking to the urgency of the matter, we have fixed the case date. Fix it on 25th September. Are you, Mr.? On the year 18th September. 18th is what, working?
That's the
25th, you lost by 50-20.
Why? Because an interim order there, that's why he's killing. He's making faces like this person. It's all visible, right? Don't make faces. All visible from here. Don't make faces when we said 18th. What is there in the case? We can hear it right now also.
No, 18th is the difficulty, some other matters. That is what I was.
So today is the convenient then.
My colleague Melody is.
No, but colleague is fine. We welcome him, but he should not make faces, right, when we fix the date.
Your Lordship may condone the youngsters.
No, we will condone definitely, but you will advise your colleague not to make faces when the court is fixing a date. Saying that it's not convenient is another view. But making faces is crude sort of a thing, which is visible.
I pardon, Millard.
You could have said to your senior, sir, 18th
is what I'm.
18th, anybody can have difficulty, like your relative may get married on 18th, you will not be here, understandable. But that doesn't mean that you should make faces.
Difficulty,
I'm sorry, Milord, if it is meaning.
But we are admitting that there will be difficulty, but making faces is not the answer.
I'm sorry, Milord, if it is.
You should be. So which other date, Mr. Zen?
25th.
He is saying that.
This later on 8, let him
The matter
Oh, whatever, don't, Mr. It has nothing to do with this thing. We are dealing with a legal issue. And if we can also put some inconvenient questions to you. Therefore, you understand, right? We are trying to fix it on an early date. Very inconvenient questions we can ask you. Your complete petition is still pending.
Have been estating this.
We can first take up your complete petition and ask very inconvenient questions to you. We don't intend to do so. We want to hear you so as to seek your assistance for deciding this legal issue. We can put very inconvenient questions to you, ask them to file objections to complete, and then ask very inconvenient questions to you. You will find it difficult to answer, and then perhaps you may be going somewhere and challenging that order. We don't want that. We want to hear you here only. So be reasonable. We have a calendar sort of thing. We are looking at it and then fixing a date, not like anything, whatever it comes to my mind.
Sorry, Mira.
26. 1 second. 26. Actually, so we can hear it on this thing. 26. 26. Yes. We have to calculate 9 days. 9 days. What will be 9 days? 9 days. They will be inversed after 9 days. So it will be inversed on 28, right? When will immersion take place, Mr. Rao?
Small sufficient.
1 minute.
Either 28th or 28th, I think, will be able. It should be, may I request.
So what is the interim order permitting you to immerse idol? Then what is your concern that there is a ban on idol immersion? The interim order does not permit idol immersion of plaster of Paris in Hussain Sagar. Does it say so?
Last year they have violated this honorable court order, Millard, and immersed in Hussain Sagar at POP. Yes.
No. So what is the interim order which is in the petition's favor?
Sell the POP idols, but not to immerse in water bodies, but they violated the.
Violated. You are a member of the Bar Association, file contempt. You are complete petitioner. What are you waiting for?
Yes, I will. This honorable court already held that. I filed contempt. If necessary, the court can open that contempt. Court can reopen that contempt.
No, there is a direction that they shall not immerse.
Yes.
And if anybody, so supposing if we pass an order to itself, you guarantee that they will not violate it this year also. Just for your mental satisfaction, tomorrow it will come that party in person argued and got this direction, right?
But my submission states
no.
Them, Millard.
Therefore there is nothing. There is already, you understand, there is already an interim order operating against them not to immerse this thing in water bodies. They can't do it. And if anybody does it,
yes,
and you are a vigilant person, you will keep a watch in Hussain Sagar. Install cameras, be there, record proceedings, who comes, who test before immersion, whether it is passed or press or not. You be there for 2 days. Do some this public and file contempt against with proof. We assure you of action. Whosoever violates will. The issue, legal issue is, immediate legal issue is with regard to validity. Write down, madam. Please for adjournment. The issue in paragraph. We are conscious of the fact that the immersion of the Ganesh idols may take place 28th of September 2023. However, by an interim order dated 21/7/2022, a division bench of this court has already directed that the plaster of this Ganesh idols shall not be immersed in water bodies. The aforesaid interim order is still in force. In water bodies, but can be immersed only in artificial ponds. Full stop. The aforesaid interim order is already in force. Paragraph in this writ petition, comma, the issue with regard to validity. Mr.
My colleague, panel council.
Last date you told your colleague that it has become infectious and we asked him why he was unable to tell. He said that Mr. Praveen Kumar is arguing before another bench. If you want to give instructions, please give complete instructions.
The panel conflict.
Yes. Textile committee, madam, textile committee, I have passed an order. We have passed an order.
Your Lordship.
The bench has passed an order on.
Here, this honorable.
We have passed an order recently, Mr. Taking note of earlier order also.
Kindly permit me to.
Yes, textile committee. Which case, Mr. WP number?
612
11.
612 2002, my lords. It came up on Tuesday, my lords, on 5th September.
5th September.
5th September, my lords. Item number 64, my lords. Item number 64.
No, this WP 11612 bar 2002 is good enough.
Yes.
Yes, get a madam, get. All right.
Earlier, three petitions were dismissed by this honorable court. Maintainability of the.
See, Mr. We are not there, but nobody was there to argue. We have passed an order and we are bound by our order. If you are aggrieved by that order, we don't say any reason to be aggrieved because it is in your favor. Still you want not satisfied, then certified copy today.
Nothing like.
Go. We have only said that they can raise objections before the commissioner. Mr. We have only said in that order that objection they can at liberty to raise objections before the commissioner to demonstrate that it can't be recovered. That is their right, even if we don't say. The validity of provision has already been upheld by Supreme Court and the division bench of this court earlier.
Yes.
We have taken note of those decisions. Record it, madam. I got passed in WP number. There is some that the one who wears specs and in the evening she comes normally. I don't know. WP 11612 bar 2002 dated.
Which
18 and 19 both, right?
Yes, your Lordship.
Yes. This one. Yes. 22. 33. Somebody was saying somebody has died.
I am 20.
Good. We did not grant adjournment. Otherwise, whole bunch would have gone, right? Good that. So what do you want? What is the matter? You come here, no? Why? Don't be with Mr. Praveen Kumar while arguing for petitioners. That too on behalf of petitioners who are no longer in this world. interfering with petitioner's possession. It is only interfering with possession.
Yes, my lord.
68 Supreme Court is in your favor, but you want adjournment. We can't do anything. Learned counsel for the petitioner, Mr. So and so. For the petitioner prays for adjournment on the ground that the petitioner has interfered with your possession. But 6.
6 years interfered, now it's.
So therefore he now so if his sons are interfering, that's a separate cause of action. You can delete his name and argue. Is it your case that his sons are also interfering after the death?
Yes, my lord.
Achha. All right.
That's the reason I intend to bring them on record.
So we are recording your submission. Right. Learning counsel for the petitioner submits that respondent number 6 has expired. Even
Me too, madam.
writ appeal 1, 2
1, 2, 3.
of
2008, your lordship.
when, madam?
Yesterday. Day before yesterday.
Huh?
Day before yesterday, your lordship. Your lordship have passed an order day before yesterday.
Some of them they said online that they to interfere for the disposition. Such cases not that similarly is ex-army. Madam, 1, 2, 3, 2, yes, day before yesterday only. Who has typed? 1, 2, 3, 2 of the total 8. So, Mr. You are appearing in 21, 21, 23. So this can be disposed of in terms of this order.
In terms of the layer.
Appearing in 20 and 25.
1 minute. 20, 23, right? Madam, correct? Yes, madam.
Yes, my lord.
21 and 23 we dispose of in terms of earlier order.
Yes, your lordship.
Giving liberty to you to take action for disposition under Encroachment Act. Yes, Mr. Yes, madam.
Appearing in item 20 and 25.
Huh.
Fair accurate. Representing fair accurate.
Whatever. So,
Already we have submitted our submissions. The matter is submitted for the video.
Where is, madam, why don't you give the file?
75.
Item 20, how can we manage without file?
Lord, in item number
Ah,
20, which
yes.
in that, my lord, the original assignee was in possession of the land, my lord. And before even he obtained an NOC after completion of 10 years.
So in
He
this,
sold the land.
madam, this is a bunch from 20 to 35, correct?
Yes, my lord.
Huh? And this was being heard, right? Correct. So,
This madam's number, my lord, 20 and 21. The numbers which have been
21, 23 have been disposed of in terms of order in WP number 1232 bar 2008, correct?
there are 4 or 5 writ petitions disposed of on 6th, my lord. I will pass on the numbers, my lord. It was on that day's list, item number 71.
No, madam, not 1232 system shows it's pending. Some other case in which order has been passed. You give
My lord,
number.
item number 71, this is 6th day's list, my lord.
6th day, 6th September, madam.
My lord, in item number 71, 76, 77, 78.
Slow. She's writing.
Madam. Chepana?
Item, I got it. This is medical batch, madam. No, final hearing she's saying.
Final hearing numbers.
They are showing you medical motion hearing cases. Yes.
Madam, 4th date, children.
No, madam. There are 2 parts of the list. One is motion hearing, one other is final hearing.
Madam.
She is referring to final hearing list. And if this person is telling you motion hearing list number. 5th September, madam, not 6th.
5th September. Numbers.
You see this list. Now, which number? Which number, madam, please?
My lord, on the date 5th, it was item number 71, 76.
Oh, madam, right. List, where is list? What is 71?
Madam.
Yes.
71 was not disposed of.
Not disposed. Hi. So she's saying 71. That's the confusion, right? That's why we are not getting the order.
76, 77, 78, 79, 83, 84, 89. 6th December. No, 5th December. Madam.
They should. Got it, madam? These are different numbers, madam. Same. So yes, this is the order. So then 21 and 23, today, same order. Yes. Yes, madam.
Item 20 and 25.
So
But in item number 20, my lord.
You are arguing 3162 now.
Yes, your lord. My lord, I have on an earlier instance passed on the status of the cases, my lord. Which gives the writ petition number, their prayer and the remarks. A bunch like this has already been passed on.
I'm appearing for the HMD.
See, madam, what she's showing that, see.
Ma'am, the papers, last time I section late now.
That is in disposed of matter, madam. Again, give an extra set, please. It has gone with that file.
My lord, your lordship may kindly peruse.
Another sheet.
Your lordship may peruse that sheet.
Make photocopy of this, right? Make a photocopy of this.
My lord, I do not
Yeah.
right away, my lord, but for your lordship's perusal. Your lordship sees that writ petition number 31682.
Yes.
Item number 20 is, my lord, 3162. My lord, the remarks column, if your lordship peruse.
So what is GIST and remarks?
Yeah, the remarks is, my lord,
No, what?
our answer. Our response is the remarks column.
What is GIST? First you will have to. Gist. Acha, we thought gist.
Gist, my lord.
We thought that what is GIST?
Sorry, Lord.
Because very often you use the abbreviation, no? That's why we thought what is GIST?
And that's the brief.
Brief petitioner's case.
Petitioner's case.
And your response.
And our response. Okay.
Weird. And this, that day we were making notes, madam. On that day we were taking notes, right? Whatever was argued, where is that? Get from that file, if so.
This one. Sir. You go. Okay. They've already sold it.
Madam, those petitions which have been disposed of, get their records here. And there must be notes. So you have noted. Okay. These the notes. So that because we are not.
Yes. Within my medicine, to tell the number which one you put, I should say. Enough, sir?
Yes, madam.
My lord, if your lordship peruses the writ petition number 3162 in the column which I have given, my lord, in the response, we have stated, my lord, that originally they were in occupation of the 5 acres of land, but before even they have sought an NOC, which is a requirement after 10 years, they have sold the land. In the remarks column, my lords, as per the records, the subject land in survey number 955 to an extent of 5 acres has been sold by the petitioner, my lord, to 2 people, my lord, each to an extent of 2.20. And now, my lord, they are reclaiming that land by the son.
So this can't happen.
The legal heir is coming and reclaiming.
Who is appearing for the writ petitioner in WP 3162? Then how can you sell the land and file, your son can file the petition? You don't have any right, correct? Yes.
Appearing for court response.
No.
The said land has been handed out to HMP, but we are in possession of the land.
That your lordships will get it at column number 8, my lord, item number 25.
Even in the.
One minute.
The writ petition number 11513.
All right. 3162, madam, right? WP 3162 bar 2004. In this writ petition, comma, the petitioner inter alia has prayed for the following relief. Quote,
That the present land is in possession of the HFA.
whatever we have dismissed the petition, we are not recording that. That only shows that it is not in your possession. That's why you are saying. Then be happy. We are not interfering with your possession.
They are admitting not we are in provision. We also filed a counter stating that it's in their provision, but given in 2000.
What order we have passed, Mister? Huh? You have heard, no? We have heard petition is not maintained and it cannot be entertained, dismissed. In his petition, you want a finding recorded that I am in possession. That we won't do. You file a petition separate to claim that, and if that petition can be entertained here, and you want to file a civil suit, do so. Yes.
My lord, now with regard to item number 25 mentioned by
22.
25.
8747.
Lordship,
This is 22 is 18747, right?
Yes, my lord, but this madam is referring to 25.
21 has already been disposed of. No.
Now serial number 25 is another number of hers, my lord.
Lordship 20 and.
No, madam, we are proceeding serially. We have heard item 20, we have decided 21, and we have decided 23. Now we are
Going back 22.
going back.
Number 23 and then 22, your lord.
Not going back because 23 was also taken up because one order was to be passed.
Very well.
That's why it was taken up, not going back.
Very well, I stand corrected. Because two numbers they are mentioning not in sequence.
18784. Where is a 18784?
Your lordships will get it at serial number 12.
Yes.
Not found. The tower of never assembled.
File, madam, you don't not giving file. I'm really surprised. How do you expect us to pass order without file?
310,000.
Who appears in 18784?
I don't know. 187.
Going back, right? I can't
N.
end it.
Prabhakar Rao.
That council for university.
No, he is A, my lord.
So who appears? What is the document annexed with the in this petition to show that there is an order of allotment?
My lord, there is no order of allotment in this case, my lord.
So what is,
He does
what
not.
is the, madam, you have to be an officer of the court. What is the basis on which he is claiming this really? Not issuing patta certificates. What basis he is claiming patta certificate?
They are saying not issuing the patta certificate.
What basis, madam?
The basis is he's an encroacher, my lord.
He cannot say in the writ petition that I am the encroacher, therefore issue patta. We are asking you to be a counsel for the petitioner first and tell us what is petitioner's claim and then say that he is an encroacher.
Very well.
Because the council is not happy here.
I stand corrected. He produced a patta certificate, my lord, at page number 39.
Patta certificate, what is the basis, brother? See, what is? So where from this certificate has come?
He is basing his reliance on the land rules vested in GOMS number 1406, my lord, at page 39.
Position says that no basis and no any other document. See what is this certificate you said needs copy. It's a Patta certificate of what? No, in favor of the question. Then what is then Patta sir? Mohammed Shakuddin. This land has been assigned. There is also 30. No. Then nothing to leave. So, madam,
Yes, your lord.
do you want to say that document at page number 15 and 40, 39 have nothing to do with the land in question and does not relate to petitioner?
Yes.
And are you in a position to make a statement that no document has been annexed with the petition to show that at any point of time this land was allotted to petitioner?
Yes, my lord. And my lord, this Jawahar Nagar, it relates to one list prepared by the Jawahar Nagar Colonization Society, my lord. He does not figure in that 102 members list. I have stated in the counter affidavit, my lord.
You are appearing in which case, Mr.?
24.
24. We are coming to your case. So we are coming across very peculiar cases where there is no allotment of land, still people are claiming. After having sold the land, people are claiming that the land should be allotted to us. After having this thing, we are this. Your cases are different with 3 cases.
We are assisting the honorable.
No, we are deciding this item 22.
Broad,
You are appearing in 22.
I'll just give a broad outline note of the whole case.
We will hear you when your number is called.
Not only till
We are seeing individual orders, not bunch. Your petition may be allowed, we don't know. This is, there is no allotment in favor of petitioner. Do you mean to say there is an allotment in item 22?
I'll just, if your lordship permits me, I'll just indicate the broad issue. The broad issue is after the Second World War, Lord, the government issued a governmental order allotting approximately about 6,000 acres of land in 8 or 9 villages to ex-servicemen. Then there were allotments made and then pattas were also given to somebody. Some of them who did not get pattas, they went on to courts and some of them are encroachers.
Why have you stood up? Sit down.
There are some encroachers.
Yes.
But ultimately, issue would be whether he is a genuine ex-serviceman A, B, whether his name falls into the category prepared. Number 3, whether there are documents to show that he was boarded out from the army and that he was given the certificate. My case are on those lines.
Your case will be, you said at the beginning, my case is different, we have kept it separately. We are deciding individually and we are entitled to ask whether, how on the what basis he is claiming that this land was allotted to me. There are no documents.
The Honorable Court can ask the query rightly, so no problem.
It's not your case, it doesn't matter.
No, even otherwise, I thought
That's different facts.
I thought that I indicate this to the honorable.
We knew this, that they are ex-servicemen given land, allotted land by cooperative society. And they are claiming that 15 lakh should not be given to us, we should be given the land so that we can cultivate.
No, I only said this so that the honorable court would have a fairly rough idea, Mr. Bose.
Yes. So, madam, there is no document of title. Fine, this petition, item number 18784, 2007. In this writ petition, petitioner has prayed for following relief. Quote. Yes. Yes, madam, which para?
Paragraph 4, Your Lordships.
Counter.
Counter affidavit.
We have heard learned additional government, whatever. AGP,
I'm a government leader for assigned.
leader, whatever. They know. So and so. In para 4 of the counter, it has been stated We will continue, madam, on Monday, whatever.
Minutes, may I request Tuesday minutes, item 39. I have some difficulty on Monday minutes. Tuesday minutes.
No, but other cases, you have a different case, right?
Yes, madam.
You and senior counsel, he was arguing.
Venugopal.
Huh?
Mr. P. Venugopal.
You have a different case.
Yes.
So which, 1 minute. 1 minute. Which item?
Item 39.
39, and will you please tell us where is other senior counsel's case?
Around their items 36, 37 and 40.
Huh?
36, 37 and 40 are the matter.
36, 37?
40.
So they have to be listed separately. Right? Your cases are different. Madam, item 36, 37, 38 also.
39 minutes. Mine is 39.
No, not
30, madam, right? 36, 37, 39 and 40. Learned senior counsel for the petitioners write their names, submit that the writ petitions be delinked from WP number 3162/2004 and be listed separately as the different as these writ petitions different questions arise for consideration. In view of aforesaid submission, let these writ petitions be delinked from WP number 3162/2004 and be listed on Tuesday is what? 12/9/23.
Deeply obliged, madam.
12/9. Yes. So remaining cases we will continue, madam.
20.
Already delinked. No, the remaining cases will come on Monday. These will be listed on Tuesday. These 4 cases, same, let there be there, same. So these 4 cases, madam, will come on Tuesday. Remaining cases come on. These are a bunch up to what case? 35. So, madam, item number 24. 24.
These numbers in all is up to 40 minutes.
24 to 40, madam, will come up on Monday. As per their whatever oldest was first and thereafter.
Lord, item 24, my lord, Ella petition.
Shall we keep this?
Yes, ma'am.
That file you keep. Then lunch motions you give. Lunch motions, yes.
Okay.
Lord, item 20.
1 minute. Monday it's coming up, right? We are
LR petition may be ordered, my lord. LR petition is there, my lord. LR petition may be ordered. First time.
We will allow that. No? We do it. LR. Petitioners LR.
Yes, my lord. Appellant.
Appellants LR. No problem. Will you correct it? Monday you can correct it. Before deciding, you tell us.
With the permission of the court, my lord, I need to give a brief note in these papers, my lord.
Please give a fresh note, madam.
This is I have not submitted, my lord. I have not submitted.
Also prepare a fresher note because some petitions from that note have been disposed of. Yes. Yes. Which case?
Management quota. Management quota, consider representation.
Page 23, madam. With consent of the parties heard finally. The order is page 25, not certified copy today. Done, madam. Previous.
This is also similar page. Same page, similar page.
Page
25.
25. Disposed of.
This is also registration B and C, Milord, same order.
Which same order?
Page 23 in the other case, Milord.
No, this is the page 25 in this case.
Yes. So it's 25.
25? Sorry? 25. Representation, Mr. Rao.
Yes, sir.
25. Certified copy. Sorry, Mr. Tai is not there. Not there. He has only moved lunch motion and has gone away. 31, no, Mr. Kessler. Mr. Madam, 31 disposed of. a good idea, right? To make judges work and disappear. The judges will take care of students. Huh? Move a lunch motion, disappear, the court will do its job. 29, Mr.
Yes,
Rao?
sir. Yes.
29. And disposed of.
Rest of all cases same, Lordship.
Pages you will have to tell, no? 6, 7, 8. 6 is what page? Page 30.
Yes,
Correct?
30.
30. 7.
Number, we do not have number. Page 22, Milord.
No, page 30. 30. See, page 30.
Yes.
Page 30, no?
Yes, Lordship.
30. Yes. 32. 22. Not 22.
Milord, 31, Lordship.
Page 31.
Yes.
No 31 in this, Mr. Rao.
33, Milord. Lordship.
No 33. Page 25 property. Come to page 25.
Yes.
WP 25104.
Yes, Lordship.
Page 25. Right. Certified copy today. Yes, please. When today? Next week, next Friday? Yes.
My lord. I am the petitioner and one of the joint owner of the land measuring 21 acres, 23 guntas, and so as per my affidavit in survey number 3, 4, and survey number 20.
Page number 3.
Situated at Raidur village, Serelingampalli.
These are so
Mandal Rangareddy
unions.
district.
Telangana Union Working
My lord,
Journalist
the
Federation.
Respondent number 5.
H143
Respondent number 5 is
and
no way
Telangana
concerned
State Union Working Journalist
with the said
Federation
property.
H9 million. Telangana Working Journalist
is trying
Federation number H2843 million.
Where are you
reading from?
Records.
In counter million, page number 8.
Direction petition is.
No, but how are you concerned with this land?
I am the.
You are the owner?
Telangana Union.
Yes, I am the one of the joint owner of the now. As per the CS number.
Joint owner of
Telangana Working Journalist Federation property.
CS number?
CS number 7.
And clearly mentioned that three recognized
Claimant.
unions. They are eligible and
Mister, you are claiming
qualified the admit
appeal in
number of the
respect of
admitted
this
card.
property which is pending
Media
adjudication in CS 58,
petitioner-
7 of
elected
58,
members
right?
also will-
Yes.
So your
Telangana
contention is that
Union
pending
Working Journalist
adjudication of that
Federation
CS, nobody else's name should be mutated in
belong to
revenue
this
record,
union,
correct?
And the elected
counter
members also will-
Correct, right?
the three unions. Only three unions millard individually they are.
Have you filed your?
Yes, my lord, we have filed for amount. My lord, in this case, my lord, the government is.
How can you issue an ID card without he being a member?
That is entirely
Is
different. my lord.
the preliminary decree, have you filed a copy of that? On what basis you are asking, which
My lord,
property?
yes. We have filed degree also.
Where is it?
Actually, what happened, sir? Due to heavy rain, my car is stuck in Shadnagar. Main file was in that car. So I am unable to.
So please
but I have
file-
already disclosed.
No,
sir.
please file-
So I
no,
can
please-
submit. Kindly oblige in that mail.
No. Please file that.
Already filed. In that, but I don't have the copy. Petition.
Which page?
Which I am unable to explain the file actually, sir. The file is within in the car. Page number also is page number 17 to 42. my-
Page is also
Yes.
on the way.
Actually, yes, sir. Car is stuck in this Shadnagar, please. Oblige, sir.
Hey, Mister, next time, don't keep the papers in a vehicle which may be stuck up, right? This is probably he's referring to page. $49. Right, okay, Panj. Yes. See what is this? CS appears to be 7. This is the application form. In the preliminary techniques, the various properties are completed and scheduled.
Subject matter petition. Please to direct the respondent number 1 to 4 not to proceed to mutuate.
No. So first of all, you have to answer the query. Where is the, my lord has asked you, brother has asked
Yes.
you, what is the preliminary decree? Where is it? There is nothing.
Decree is there, sir.
Some nice photographs we are seeing. Apart from that, there is no decree.
At least have you ascertained a copy of the report, counsel?
Yes.
Have you ascertained a copy of report? A new report has been filed. Please
Everything,
ascertain, and if you have objections, first you answer to that.
my lord. Yes, if you provide me copy, then I get.
You are not annexed it, madam, Mr. Only application. Only application you have filed.
Detail numbers I can actually material papers 17 to 21. CS 17 to 42, my lord. CS number 7 of 1958, 17 to 42.
Preliminary decree. You filed, Mr. It's not there. Hey, what is Mr. That means you have not even read the petition, right?
17 to 42.
72.
17, sir, my lord. Page number 17. 17 to 42.
That is also application. It's an application. See.
No application, this is decree, sir, my lord.
Where do we get that? Where do we get the schedules of the property? Please follow the question.
Yes, my lord. Copy of the proceeding number. Page number 43. Now. Page number 43, my lord.
Tell him he has not filed, we will grant him time.
44.
43 is proceedings.
Proceedings, 44.
We'll grant some time. You have filed some sale deeds, and what we want to know is a copy of the preliminary decree where this schedule is being mentioned. You please go through the report. To our understanding in CS 7,
yes,
only movable properties were shown in the preliminary decree, in the compromise decree. Better verify it. These immovable properties are added to that.
1 minute, my lord.
And we are. So that's it, Mr.
One, my lord.
You filed the copy of preliminary decree passed in CS.
My lord.
How much time?
3-4, 1 week, my lord. Because they are trying to mutate. They are trying to mutate, my lord.
Nothing happens, sir. Even if it is mutated, nothing happens. Mutation does not create any right. You understand, right? Mutation of revenue record doesn't create any right in favor of anybody. But first we want to know that this is what is the basis of your this thing, title to the property. You just want to, without filing any document, you want an order of stay. That's not fair, right?
My lord.
If you are willing to file, then we will grant time. If you are not willing, we will pass an order.
Willing to pass, my lord. Yes, within 1 week.
In this writ petition, the petitioner claims to be the joint owner in respect of
Please. The order implementation repetition is, my lord, the proceeding issued by the collector.
yesterday but last time we could not hear you. Your appeal.
Not,
Wherever, we wish that you are there in International Court of Justice. Why confine yourself to Supreme Court? You should address us next date of hearing in Hague and seamless without any interruption. Wish you all the best. Yes,
Presenting respond number 8.
yes, please.
But page 24 is, my lord.
Yes.
Page 24 is the, my lord, proceeding. Which is under
asking
challenge before my lords.
Sir, same question.
Yes.
Have you filed a copy of the preliminary decree?
So far as the
Have you gone through the report at least? The report has been filed in CS7 of 1958. Have you gone through that? Other councils took time to file objections. You have to say that whether this is part and parcel of that, whether it's the property, subject property, immovable property is part of that preliminary decree.
But my grievances are a different footing in the present case. Under the guise of the survey, possession is sought to be taken over us by the respondent authorities at the instance of respondent number 7 and 8. But so far as the petitioners are concerned, they have final decrees issued in their favor before by this honorable court, and registered documents are also there in their favor, and the possession was also delivered to them under the complaints reports were also there in favor of the petitioners.
Where is the final decree?
Yes, but so far as the first petitioner is concerned, the final decree 24/9/2013, which is at mark, which is filed as exhibit P3 at page 81.
No, but Mr. C, supposing if you are in possession and respondents are trying to dispossess, then file a suit seeking the relief of injunction. Why writ petition? We don't grant a relief of injunction in a writ petition.
But I am fortified by a judgment, division bench judgments of this honorable court, where under the guise of survey, existing possession cannot be unsettled is what is the law laid down by this honorable court.
This is a number. 1 minute. You will agree that who is in possession is a question of fact. Forget about this case. Supposing under Article 226, we have to record a finding who is in possession. That's a question of fact.
I am not called upon.
Just a minute. Forget about this case. We are asking you as an officer of the court. Forget about this case. We will revert to it. Why we are trying to explain the context in which we are putting you the query. You should understand, then answer. You don't be involved with this case. For a moment we are asking you, like, it's correct that even if you don't agree, we will have to hold so that question who is in possession is a question of fact, correct?
But I
1 minute. It's a question of fact in any proceeding in a writ petition, whether A is in possession, B is in possession. Supposing you claim to be in possession, R8 says that no, I am in possession. So it's a disputed question of fact. Then secondly, you are saying that they should be restrained from carrying out any survey demarcation of the land in question. Right? Whatever land. This is the prayer, right?
It is not his case that he is in possession.
No. We are trying to understand. Mr. We will hear you. Acha, all right, you argue in your own way.
Yes.
We will not put you questions. Go ahead.
Only one thing,
But
sir.
the petitioners,
The Lordship permits, they are seeking an order that survey should not be conducted.
Ah.
The Lord, I have filed my detailed counter affidavit today, but otherwise also I am given to understand the survey has already been conducted in July 2023.
When?
July 2023, I understand.
Election 12/7 and 13/7, 14/7 and 15/7 survey.
13/7. You know what dates means?
12/7 to 15/7 survey has been completed,
Completed after notice to petitioners or without notice?
Issued notices, petitioners for issued notices are not I need to assign.
I had requested for that survey. My lord, they had, as I understand, they had filed objections. As far as I know, my lord, their objections.
We only want to know whether this thing, let him first argue, then you can point. Yes, go ahead, Mr.
But page 24, your lordship may kindly see, my lord, which is impugned before my lords.
No, what you are what?
Which?
You are owners of this land, right?
Yes, my lord. We are owners of, my lord, land.
Where is the, you have purchased it by sale deed?
But by a final decree, my lord, passed by this honorable court.
In partition, what?
Yes, my lord. Under the, so, my lord, so far as first petitioner is concerned, my lord, there is a final decree, my lord, passed by this honorable court, which is filed at the
Final decree, we would appreciate if you say in a suit for partition.
Yes.
So we will know that in a family partition, this land has been allotted. You are only referring to final decree, final decree. Final decree in a suit for partition or what?
in a suit for partition.
That's
Petitioner,
put up, no?
Yes,
By virtue of final decree passed in a suit for partition.
yes.
What is final decree dated?
But final decree, my lord, in respect to the first petitioner is, my lord,
Date
24/9/2013.
in
In application number 910 of 2013. At page 81 to 88 page.
910 of
910 of 2013.
Page 81 to
Page 81 to 88.
in respect of petitioner number 1.
With respect to the petitioner number.
This is a partition suit, right? Decree, final decree part.
Partition suit in a partition suit. For an extent of 1 acre 14 guntas.
Respondent number 8 is a party to this suit.
He is also part. Respondent number 171 to 172. Yes.
8 who's here?
Yes, my lord.
You are party to this suit.
Yes, my lord. My vendors.
That's yes.
Vendors are party. And another, my lord, exhibit P7 is another final decree.
No, so how many petitioners? You have said in respect of petitioner number 1.
Yes.
So what are the remaining?
But there are, my lord, 8 petitioners before my lords in this writ petition. 8 petitioners. And there are 6 final decrees which are passed by the 5 final decrees which are passed by this honorable court. And so far as the petitioner number 4 is concerned, my lord, he belongs to the original family for which partition suit is filed. The second final decree is dated 26/6/2014, which is marked, my lord, as exhibit P7. In application number 778 of 2014.
AS number 778.
Application number 778.
It is not a suit. This is not a suit. Previous was suit.
CS is suit, my lord. Final decree.
You have told us previous AS number is what?
That is also application number, but all are application numbers, not AS.
What is application number?
Application number in this case 778 of 2014.
No, what is I want to understand.
Final decree. It's an application filed for final decree. 778 of 2014.
14.
And there is another final.
No. So this is in respect of which person? Petitioner number?
Petitioner number 3 million.
Then final decree another.
Final decree in respect of petitioner number 4 million. That is exhibit P9 million.
Date
19/9/2013.
This all you could have given in this thing, right? Chart. Just repeating like this, and we are writing exhibit P4.
Exhibit P9 million. Final decree application number 855 of 2013. 855 of 2013.
So we have 1, 3, 4.
In respect of petitioner number 1, first one is 1 and 2 million. First one is petitioner number 1 and 2.
Only one use.
1 and 2. I'm sorry. Yeah, 1 and 2.
1 and 2, 3, 4.
Yes.
Yes.
And then
5.
Another final decree, exhibit P10. This is in respect of petitioner number 1, 5 to 7 million.
Again 1.
Yes. In that final decree is also petitioner number 1 and 5.
Date.
Date is 30 12/2011.
Application number
Application number 519 of 2009.
519 of
2009.
yes.
And another last in respect of petitioner number 8 Millard. This is exhibit P11 is the final decree Millard passed by this honorable court. Dated 30/10/2013. In application number 856 of 2013.
So your contention is by virtue of final decrees, you are the owners of these lands.
Owners of these lands. And Millard, the procedure that is followed by this honorable court when passing final decree is Millard, receiver is given and he has put the possession of the respective extents in favor of the petitioners and the complaints reports are also filed.
All the applications, respondent number 8 is a party.
Yes. And they were put in possession.
Therefore, this orders passed on these application number bind the respond number 8 also.
Yes. Yes.
Then, so
and
what happened?
They were put in possession and complaints reports are also filed before this honorable court.
You are owner and in possession.
Yes.
Then what happened?
And now, Millard, there is another thing, Millard, which is so far as the
This was issued on 24/5.
No. It is not a notice, Millard. This is impugned order. I'll come little later to the impugned order, Millard.
This is you are arguing on admission, right? Not
Yes,
final hearing.
arguing an admission.
And not final hearing.
Final hearing, I'm conscious. But because of that, I need to satisfy with this is a CS7 matter, Millard. But how the fraud is being played now, you may kindly see the respondent number 7 and 8. They have filed a suit for injunction. In respect of 73 acres, and that suit in OS number 863 of 2007. Suit in OS number 863 of 2007.
Was 73 acres of what survey number?
All are in respect of survey number 57, Shamshi-Goda village. Now the respondents have gone to civil court, filed a suit for injunction in respect of 73 acres.
Seeking injunction what? Seeking injunction for what?
In the interim injunction, releasing that they are in possession.
No.
See, they sought an injunction decree.
You said civil suit for injunction. So, 1 minute, civil suit for permanent injunction.
Civil suit for permanent injunction.
That's why, I mean, you are permanent injunction.
863 of 2007, Millard.
863 of
2007. On the file of first additional district.
What is the permanent injunction sought for in this suit?
Permanent injunction that they are in possession and the respondents are interfering. That suit was dismissed.
Restraint from interfering with their possession.
With their alleged possession. That was dismissed by the.
1 minute. We are writing, right? You all.
I'm sorry.
You should have done was to write.
I would give Millard.
This all, I mean, admission matter. It's taking time. Everybody is waiting. Listen to your erudite argument.
I would Millard give enough. This suit was dismissed. They filed appeal before this.
1 minute. When it was dismissed?
This was dismissed on 26/4/2011.
No. So this is in respect of part of this subject.
73 acres.
73 acres out of 92 acres.
Right. So 73 acres they sought for. It was dismissed, and they carried the matter to this honorable court. And a division bench of this honorable court was pleased to
also dismissed
their
when?
Yes, that is on 26/8/2013. AS number 293 of 2011.
8.
AS number 293 of 2011, my lords. Which is filed at page 401.
Then proceed faster, Mr. We have something better to other cases to hear.
And then they filed an application, my lord, in a CS, in the present CS itself for delivery of possession. That application they filed on
CS? Appeal suit?
No. In the CS, the present CS7, filed an application for delivery of position.
They means who? R7
7 and 8. They filed an application for delivery of position
in CS7.
in CS7 void application number 930 of 2013. Direction to deliver
930 of
930 of 2013. Seeking to delivery of total extent of 92 acres. This application was dismissed Millard on 21/3/2023.
21.
3/2023. After Millard, they have even the application for delivery of possession of this is dismissed. But in the interim, Millard, there is some development that have taken place. Government challenge and recall applications were filed before this honorable court. Those matters carried to the honorable Supreme Court, and the government claim in respect of survey number 57 was dismissed, and the recall petitioner's claim was also dismissed, Millard, because that was adjudicated by this honorable court. Recall should not have been decided like a review, and the application that is filed for recall is
That's why we were telling exactly this we were telling in the morning to a learned counsel. He said that he has filed an application for recall. We told him that there is a distinction between recall and review.
That was dismissed, and now Millard, their claim.
You file counter.
Having lost all this, now
We are asking them to file counter, not satisfied.
no, not counter, Millard. It is the respondent number 7 and 8, Millard. Now that is crux of the matter which I am coming now, Millard. After they have lost their suit for injunction, now they have come before the revenue authorities seeking, kindly see, that is why Millard, I requested now impugned order, kindly see page 24, Millard. You will actually find reference at reference number 8. The representation that is submitted by respondent on behalf of respondent number 8, 7 and 8, 22/5/2023. Reference 8 minute. Now kindly see page 25, third paragraph. He has explained what is that reference. Through reference 8 cited, Sri Sripad Deshpande has submitted representation and stating that required to enter into scheduled property for taking over physical possession of the same, like fixing the boundaries to schedule of the property, and same is possible by fixing boundaries of the scheduled property, our survey Shamshiguda. This is Millard entertained by the district collector without any jurisdiction, and a division bench of this honorable court held Millard. The survey is not meant for delivery of possession. Having lost in civil suit,
No, where is the order?
No, this is the order, Millard, which is given by him, appointing for the purpose of
You switch off.
that is the
You
order.
get unnecessarily agitated. We are asking questions. Switch off the mic, we said, because our hearing faculties are proper. Because you start shouting and Mister, we are, please understand two things very clearly. We are not your enemies. We are, no, 1 minute. We are not your enemies. And our job is to find a solution to this legal problem according to our best of capacity in accordance with law. Our decision may be wrong, right? That you have 1 minute, you have a remedy. But please do not be a professional, do not shout like this thing we are only trying to understand what is the controversy, right? So therefore, in a cordial atmosphere also, arguments can be enhanced when we are not subjecting you to any misbehavior, and we are writing with all seriousness. I am taking down the notes, right? Court is taking down notes. No need to shout. Yes. So where is the order? Order, we want to understand. Where is this order saying that we will take possession in the garb of survey as you are putting? Where is the order? Last line, please read it again. Is this only survey? No, he cannot, senior counsel cannot argue that in the garb of survey possession can be taken. And 1 minute. He cannot argue. We have not heard it, but we are telling him in all space that he cannot, being designated senior counsel, he cannot argue, and being an officer of the court, he cannot argue that in the garb of this I will take possession. Number one, this position. Secondly, we cannot in 226 record a finding that you are in possession and grant injunction. Good thing. We will clarify this, that in pursuance of, if that is your apprehension, we will clarify at the outset that in pursuance of this no order dated 24/5/2013, nobody shall be allowed to take possession. And if survey has to be conducted, you shall also be heard. You can file objection. Survey shall be conducted in your presence. These two directions we can give right away. Correct. There's, apart from this, this is an apprehension that you will. Who is jurisdiction? What circular? So, Mr. This is what you should have said, that I am assailing this on two grounds. Number one, this is under circular so and so, he is the officer, whereas it is issued by circular. You are making us long this thing. Lot to learn, Mr. Lot to learn. See, clarity is one of the biggest assets of an advocate. You always bear in mind. So, what circular? Circular. Which circular? This is what is a statutory power, statutory delegation or what? Statutory or administrative statutory? Under which provision of law? Which page? No. This has been reproduced in that order. No, reproduced in that order so that we know what is interpreted. Because when we say that under 25/7/21/2001, only our revenue divisional officer is able to carry out survey, then we must have that order before us. No, please produce that. So first submission is 1 minute. Now let us cut short what you could have argued in 2 minutes. That collector has no power to direct survey. Number one. What is the second? What is this page number, Mr. 352? And what is the other submission? That in the garb of survey, possession cannot be taken. He can make. You can also make any application, right? You can make an application, your client, that I be appointed President of India. We cannot prevent. How can the court control whatever they write? We have to, your submission is that in the garb of survey, possession cannot be taken. Correct. These are the two grounds. So having lost, having 1 minute, having lost the civil suit, therefore no right to seek survey. We cannot stand on that land and guard you, right? This all excellent grounds for seeking prima facie case, balance of convenience, irreparable injury. This is all this thing, photographs and all this. Who has taken photograph? All these questions, because value of the property may be according to you in thousands of crores. Therefore, writ jurisdiction, right? And we all should say, oh, this bulldozer is standing there. We must ensure that this bulldozer is parked away from your land. This area is fenced. We give a finding that you are in possession. Then depute a army of 15 people with AK-47 to protect your land all the time so that he doesn't enter even in the vicinity. All this is 226, right? Three. These are the three submissions. Where is the order dated again? That this thing, where is circular dated 25th July 2001? You place. No. Circular did not file, please file. Because we are unable to interpret. No, shall we say that you are refusing to file, therefore petition dismissed? Therefore, this ground is not available to you, that it is without jurisdiction. Because until we see, we cannot decide. What is this, Mr. Learned Counsel, in this writ petition, mark their presence. No, nothing, no meanwhile. In this first file circular, we are taking it up on the next week. Learned Counsel for the petitioner. In this, mark their presence. In this petition, petitioner has asserted the validity of it primarily made on following grounds. Number one, collector has, see, Mr. Senior Counsel, we are amazed by these orders. That only shows the value of land, how much is involved. So, and there's nothing, it doesn't create any title, nothing happens. But despite that, see, with the vehemence with which it is argued in a writ petition, the collector and district magistrate Mitchell, collector
I represent
Staple that.
but in this case, I beg to represent Mr. Sarah.
Your lordships to examine by doing it. May I have your lordship's name?
What SLP?
May I have your lordship's leave to make a prayer? In the earlier declaration below.
Counter to be filed by 153.
Have you, sir?
Have you filed counter?
Not yet, minutes.
That-
File our counter minutes.
Invitation, right? You are waiting for invitation card to be sent.
It's a review petition minutes, which is for the court to.
No, we don't know review petition. There is an order like this. You want a PT, mister?
Sorry.
No, I was not there on 20th September 2020. I had to tell you the order and then you are saying that it is not necessary. So we will record this.
Yes, I'm aware of the.
Even though time was granted on 20th March, 29th September 2020, yet when the matter is called today, learn it, Mr. So and so, learn
I'm
it.
extremely sorry.
Government.
It to be drawn, my lords. That is the observation made by the Honorable Division Bench, my lords. That's what.
Yes, please. They don't want to file a counter. Go ahead, Mr. Counsel. What is it?
Para 3 of the order, my lords.
My lords, in this matter, Anita Swain Miller, due to personal income, is not able to attend, my lords. The council
No, no.
petitioner.
This is a review petition for review of the order dated 14th January 2023.
Yes,
What ground you are seeking review? What has been done?
I've been asked to represent on behalf of Anita Swain Miller. She has some personal inconvenience today, so not able to attend, my lord.
You are not the petitioner.
I'm representing Anita Swain, my lord. She asked me to represent.
Whatever is, Mister, we are not interested in name. We are asking you, are you appearing for petitioner?
No, my lords. I was asked to make a request on her behalf. That's due to personal inconvenience. She is not petitioner. He is review petitioner, my lords.
No, do this. No, but he is appearing for
Review petitioner, my lords. For review petition.
You are appearing for review petition.
I'm sorry, my lords.
You can't say this that I am appearing for review petitioners and I want adjournment. You are saying all sorts of things. So and so, Swain, so and so. How does it matter, Swain or whatever?
But she requested me to make a request on her behalf, my lord. That's due to personal inconvenience.
That's correct. You need not repeat. It is not such a complex problem that we can't understand. Right? Our faculties are all right. We can understand this much that she has requested you to seek. You are repeating it twice. The only harmless question was for whom you are appearing. Because this senior counsel was trying to say something. We thought means review petitioner. Then you are standing there and not telling.
He was representing earlier case, my lord.
Kindly see the order. Kindly see the order under review, my lords. Page number 15, my lords. It starts from. Relevant is at page number 19, my lords.
Was representing item 154. He wanted 2 weeks time. Lordship posted next week. He was requesting for 2 weeks. The earlier case, my lords.
Mr. So and so prays for adjournment on the ground that arguing counsel. Delete that counter thing. Then why should you not tell the court that in 2020 only that I don't want to file counter?
In the year 2023, January, my lords, order was passed, my lords. Against the challenging that, my lords, they have preferred review petition, my lords.
Counters have been filed, my lord.
Your lordship,
We have filed the counters, my lord.
When?
Lord,
I am for the petitioner, my lord.
Establish your lordship.
I need an adjournment, my lord, because they file counter, my lord, I want to file reply.
Direct counsel for petitioner, praise warrant is granted 4 weeks time to enable him to file reply to the counter filed on behalf of this.
My presence to be marked, my lordship.
Mark his presence.
Much obliged.
Yes.
Much obliged.
Yes. Huh? 157. Yes. In IA 1 of 20, this court by an order dated, which order? This court by an order, this court had appointed. No, this court.
Already, that's already interim orders are there, my lords, in this matter, item 158 minutes. Already interim orders are there, my lords.
Which case?
In 158 minutes. With regard to registration of flats, my
No,
lord.
no, so we have fixed it on 22nd September, after 2 weeks.
That's 158, my lord.
Next matter.
Next matter, my lord.
People there.
158.
Yes, my lord. This is with regard to.
This was 157, right? Sorry, 157.
This is with regard to submission of report by the commissioner, my lord. Report is awaited, my lord. Just now, my lord, so please to appoint a new set of commissioners, my lord. Matter for
Report of the commissioner in this petition is a.
The thing is, as far as the report is concerned,
No, interim order is continuing in your favor.
the lordship is attending these matters for want of report. For want of report from the new receivers. But under what circumstances, the lordship?
You want to argue, right?
We can wait for 2 weeks and appear matter will not be given some time for the receivers to file a report. But there are.
No, we have appointed to, what, we have to explain it to you? No, we don't owe any explanation.
We have heard.
This order has been dictated, whatever. You can, if you are aggrieved,
We are not.
not good.
We are not even agreed. What we are really saying that general time, otherwise there is only on the ground that the receivers are appointed. The matter-
Mister, let them breathe first. And thereafter, we have given a date for 22/9, only to fix a time limit, right? We have said, Mister, we are not here to explain our orders. You obtain the copy and challenge it. Or seek modification, review, whatever you want. That erred in not fixing a date for submission of report and error apparent, whatever, or challenge it before Honorable Supreme Court. We will not explain our orders to you. We are, your cases 158, please make submission.
It can wait for 2 weeks. 158, you can wait for 2 weeks because there is an interim order.
interim orders are there, my lord, already.
2 weeks? What 2 weeks? What do you think? Report to commissioner will not submit the report.
Yes, I'm aware.
It has to go after 4 weeks.
Yes,
Awaiting report of the commissioner list after 4 weeks, interim order shall continue. What else? How many cases in this single? Admitted for hearing notice.
Item 161. And the petition is present application is filed, the appointment of solar arbitrator.
Admit notice.
And leave petitions.
Leave issue notice on IA one of, you are not a party to arbitration agreement.
Phone number 20 is not party.
Delete, madam, admit. Issue notice of IA 1 of 20.
I can see you like it's your.
Fresh application, your lordship. Arbitration clause is at page 102, your lordship.
Admit notice. Personal service. Proof of service.
Obliged.
Just you are required to wait for hardly not less than 2 minutes, right? Huh? We want, you are all senior counsels, we want that youngsters should look at you and should know what is the virtue of patience. What, yes, madam, what? 2 weeks time were granted to you. On 17/3/23, again you want time. How much time? No, we don't know, whatever issue. How much time do you want? 2 weeks for the time is granted.
It has been pending for a year.
Nearly 1 year, no?
It's a posted fine. Please.
This thing, madam, you were granted 2 weeks time on 17/3. Huh? No. 2 weeks time. Thereafter, how many months have passed? 6 months. And still you want 2 week time. This is not this. No, you file within 1 week. Otherwise, go to Supreme Court. We will file it on, we will fix it on 15th. It can't be a civil suit, right? Proceeding under 11(6), you cannot keep it pending like a civil suit for years together. No. Mark the presence on so and so on 17/3/2023. 2 weeks time was granted to the
Weeks time allots in this matter.
This is still 11th February you were granted. 6 months exactly. 7 months. On 10/2/2023, notice of the application was directed to be issued to the respondent despite service.
Paper petitioner, I filed a counter today, my lords, 100 pages counter is being filed, my lords. Lordship may give me to
Ensure the, see, keep it ready, file it on the day when it is listed. So it results, see how this thing. Huh? When do you want?
It's next Friday, my lords, I'll argue the matter.
Learned counsel for petitioner submits that respondents 1 to 5 has filed the counter today. He prays.
May it please, my lord. I appear for the applicants in this matter.
Yes. Arey, Mr. Rajshekhar, you were seeking adjournment, so we.
I was not seeking.
Yes.
My friend was asking for it.
Adjournment.
Asking for
Yes.
filed my counter, my lord, it is not there.
My lords have requested them to serve the counter beforehand and get ready today.
But
I am ready, my lord, with the, I have read the
but
counter.
counter is not there, right?
Yes.
Next week,
Very
15th, learned senior counsel for respondent submits that he has filed counter on. Counter is not there on record. Yes, counter has been. Which date, Mr. Filed? Which date you have filed counter? Ask your instructing colleague.
Today, my lord. Today they have served, my lord, it is filed today only.
That's what he is not saying.
Yes, he is not saying.
Learned counsel, senior counsel for respondent submits that he has filed counter today. However, the same is not on record. Office is directed to trace the same and place it on record. List on 15 September 23.
I'm appearing on behalf of P. Ravi
Yes.
Shankar, the respondent, Your Lordship. Today itself, we have served the counter.
Yes.
167. I'm appearing on behalf of P. Ravi.
63 to 167. Yes, madam, counter.
Counter, morning itself, we have served.
No, you are appearing for petitioner.
Respondent.
Like, why are you standing for petitioners? These things are not visible to you people, right?
I am appearing for petition.
That's yes, Mr. That is the problem. We thought that she is appearing for petitioner, and we thought that she's saying we have filed counter. So I was confused. Yes.
Counter is solved today in the morning.
Yes.
Next week.
Shall we take it up on 15th?
Much obliged.
Learned counsel for the petitioner submits that the copy of the counter which has been filed on behalf of respondents has been served on him today only. He therefore prays for short accommodation to enable him to go through the same list on 15 September.
Much obliged.
Is 167 to 170.
Only other cases,
Yes.
Other cases, except 168, all other served, they are not appearing.
All right. So 160, 168 they are appearing.
168 notice is returned unserved, I am sending a press notice.
Acha, 168, madam, then don't write. This order in 167, 168 postal endorsement indicates that the 168 notice issued to respondent has been received back unserved in view of aforesaid office note. Let fresh notice be issued to respondent. Personal notice and that.
Maybe 6 minutes.
We don't know what time will you serve. Please serve and then make a mention. We will take it up. 169, Mr.
All other matters they are solved, they are not appearing.
169, none appears on behalf of the respondent. Let the petition be listed on 15/9/2023.
170 also.
170 also they don't appear.
Yes,
Despite service of notice, you write despite of service of notice, none has appeared on behalf of respondent. List on 15/9/23.
Much obliged.
169, 170. Right.
Made the lordship.
Yes.
Lord, I'm appearing for respondent. We have a
You wanted time.
reputation. No, my lord, I
File counter.
don't file any counter. Only thing is, my lord, we want to raise an issue of limitation in this matter. Your lordship may give us liberty to raise it before the arbitrate.
Proceeding. Yes. That claim is barred by limitation.
Yes.
So, yes, tell us an agreed.
My lord, if I may suggest, similar matter by the claimant is pending, my lord, before learned senior counsel Mr. L. Ravichandar against the brother of this respondent. So if your lordship can appoint.
Some retired judge may be appointed.
I leave it to your lordship, so because I just.
No. Give us an agreed this thing, name we could have.
Senior counsel L. Ravichandar sir se baat chal raha, similar matter. I leave it to you.
Give madam. You see the list of former
Your
judges.
lordship may call it at the end of the list. I will verify from my client and he report.
End of the list is only 2 matters, madam. So be quick, right? We are passing it.
Yes.
Be quick. Yes.
Lordship is not, I'm for the response.
For the applicant, your lordship.
We'll file a counter, your lordship. Kindly grant us 2 weeks time, your lordship.
So you are appearing for respondent.
I am appearing for respondent.
So 18 it also 3 weeks time was granted.
Yes, your lordship. We file wakalat on the day, your lordship.
1 week. Failing which appropriate order. Mark the presence on it. This is not a civil suit, Mr. You cannot drag on the proceeding under section 11 like a civil suit. Understand? There is no limitation of 90 days for filing a written statement here, which can be extended to 120. Extension.
Yes, madam. I am appearing for the applicant. That we have instructions, my lord. We have no objections for extension of time.
Oh, great.
We have sought 6 months of time for extension. We have no objection.
Yes, this petition has been filed. Seeking extension of time for conclusion of the arbitration proceeding concluded by initiate. $174.
This is also an application seeking extension of time.
Same order.
But other
And
side is not there, my lords.
not there, we have to what notice then of your
Perhaps,
application.
my lords, because the section 11 application, it was passed because nobody had appeared. My instructions are the council before the arbitration, he has no objection, but nobody has appeared. That's why I'm only
I know later on he may say orally and challenge later. Why to take risk? Notice. Issue notice of IA 1 of 23 to respondent personal service and proof of service. List on 22nd September.
Very well.
Yes, madam.
Contact him, but in another 10 minutes, I believe both of us will arrive at one name and get into the program.
So either it's the
Mr. Ravichandran or some other.
the former judge, right?
With your kind permission, your lordship.
1 minute, madam. This matter is going on, right?
I apologize.
This petition under section 11 within bracket 6 of the Arbitration and Conciliation Act has been filed seeking appointment of an arbitrator to adjudicate the dispute between the parties.
It's a partnership agreement, my lord, limited liability.
Parties had entered into a limited liability partnership under LLP agreement dated 17th of party that the petitioner that the parties had entered into a limited liability partnership under limited liability partnership agreement dated 17/12/2015. 17/12/2015. Clause
39, my lord, page 30.
Clause 39 of the aforesaid agreement contains an arbitration. First October 2023 at 11 a.m.
Needed, I'm ready to cooperate, I need it.
Yes, September or next week.
30th September is fine.
I'm ready, I'm ready.
30th September 2023 at 11 a.m.
Issue of limitation, my lord.
11 a.m. Needless to state that the respondent shall be at liberty to raise an issue that the claim made by the petitioner under the agreement is barred by limitation, which shall be duly adverted to by the learned arbitrator.
Obliged.
And then accordingly petition is disposed of. And give the name, madam. So we have kept it blank, right?
10 minutes.
10 minutes.
Obliged.
Madam, please tell me what is the name given and then type. Tell me and then she will type. Yes.
Kind permission, Your Lordship. An arbitration application of 2015, Your Lordship. Orders were passed in 2020 with regards to appointment of an arbitrator, and an extension petition is filed, Your Lordship. The date, the arbitration
Everybody
expired.
was mentioning, where were you, madam?
Your Lordship, I was
Next week.
much obliged.